Good morning. A grave murder, rape, child rape, POCSO case was tried and death sentence was awarded. That was confirmed by High Court. Then Supreme Court acquitted the who was languishing prison for so many years. On these grounds, this is ratio which will help you to conduct POCSO cases, grave cases. I would like to share the judgment which running multi-member of pages, and you can very well download and read it patiently. But ratio I would like to discuss by explaining the what about the appreciation of evidence by the Supreme Court. This is AR 2025 Supreme Court 3186. AR 2025 Supreme Court 3186. Ram Ki Raat Munilal Gaud versus State of Maharashtra. First ratio was that the FSL report created by the subsequent investigating officer is unworthy. Ulterior motive it was created. They say the mud available with the shoe of the accused was compared with the pond where the child was found dead. So even that report not supported by the expert. So therefore that was flawed investigation, tainted investigation held by the Supreme Court. Then question arises: the extra judicial confession. See, the person who says initially to the first investigating officer that when he did not turn to, the accused did not turn to duty, when he said simply made a mistake and he seems to be tense. But subsequently, before the court, he says that he confessed. Therefore, that apart, even when the entire village was searching for the child, and definitely the person before whom extrajudicial conference was made ought to have immediately reacted and informed the police about the suspect character of the accused. Therefore, that extrajudicial confession was also not believed. Then question arises: lost scene theory. They have said police officers regularly searching in the area. Therefore, the lost scene theory has put up, tainted, fabricated by the investigating officer may not be reliable. They say it was vacillating, shaky and tainted with improvements. That was there. Then this is collecting of FSL, collecting of samples from shoes recorded at the instance of accused. And they say there was possibility of accused being roaming near the body where the child was floating. That was their way, say they say. The Supreme Court has worded the entire investigation shabby and perfunctory. Shabby and perfunctory. Shabby, SHABBY, and perfunctory, FPERFUNCTORY, without paying attention to everything. The investigation was hushed up, and this is what had happened. Got acquitted after long years. Best wishes.